Talking about the top 5 questions that people ask when they're going through parenting matters. So the first question that we usually get is, what are my rights in relation to parenting? So the basic rule of thumb in relation to this is, while there are no orders in place, there are no rules as to who gets the child. So, and this is between biological mum and dad or partners. So whoever has that child in their possession, they do not have to technically hand the child over to the other parent if they don't want to. But in saying that, I do stipulate it doesn't look good for the parent if they're actually denying that time. But legally, that's the rule. No orders in place, no rules as to who should have the child, whether you're dad or mum. Just because your mum doesn't give you an automatic right above and beyond the father. So that's a really important thing to note. Now, the one thing I will stipulate about this, though, is grandparents. Grandparents do not have rights over children. So if a grandparent has a handle of children or has the care of children, and the biological parent walks up to that grandparent and says, I would like that child handed over to me, then technically they have to do it. Unless they have an order from a court, they cannot actually withhold that child. Otherwise, they could actually be potentially charged with kidnapping of a child. That has happened quite a few times, so be very careful if you are the grandparent in that situation. So that is the first question that people ask. So the second question we have asked regularly is, the other party has taken the children, what can I do? So obviously from the first question, the rule is if someone's taken it, there are no orders in place, then there is no rights as to who gets the children or not. But what you would have to do is you do one or two things. If the matter is urgent, as in there is a risk to the children, you would need to file in the court immediately for orders for the child to actually be returned to you or to get parenting orders in place. But if there is no urgency or there are no genuine risks to the children, then you're going to have to go through the legal process, which means you're going to have to go through a family dispute resolution process first. So in general terms, you would know that as a mediation. And you can do that by either going through private lawyers who can organise it, or you could go through things like Relationships Australia or relationship centres. You'd have to go through that process first to try and come to an agreement, and then after that they would issue you with something called a Section 60I certificate, and then and only then will you actually have authority to be able to file an application in the court for orders in relation to children. So that is the basic process that you have to go through, unfortunately. So what I will say is, if the other party has taken the children and they return them to school or somewhere else, you can walk up and actually physically take those children, and they can't prevent you from doing so. If they try to physically take them out of your hands, then they can actually be charged with assault, or you could get a domestic violence order. But as a general rule of thumb, that's what you'd have to go through and do, okay? So the third question is, can I move with the children? And if I can, how far away can I move? So this is an interesting question, and it really depends upon your personal situation and how often the children are having time with the other party. So if the other party is having time with the children, let's say week about or every second weekend, then if you move away, you still need to be able to maintain that relationship and that ongoing parenting arrangement that's in place right now. So if it's every second weekend, you're not going to be able to manage that if you're moving interstate, probably. So you would not be able to move. So basic rule of thumb is, once you start moving up to 40 kilometres away, 20 to 40 kilometres away from the other party, then you're going to have to start looking at whether that is what we consider a relocation matter, and that might be problematic. Now, if you are planning on moving interstate or significant towns or kilometres away, and the other party has said no, they don't want to go, or don't want you to take the children, then your only option at that point is to do one or two things. One, you can go and see if they bring an application to the court. It's called playing a game of chicken. The other one is to bring the application to court and let a judge determine whether you're going to be permitted to go or not. That, I will say, from my perspective, is sometimes a difficult application to be successful on. So if you're going to move, you're going to need to have very good, strong reasons as to why, and you're also going to have to think about how you're going to maintain the relationship between the children and the other parent if you do. So I hope that helps in relation to that question. So number 4 is, can I withhold children? And if there are no orders in place, then technically the answer is yes, you can, but you want to be very careful about when you do, because it may make you look like you're actually alienating the children from the other parent. But the main time that this question comes up is where there actually are parenting arrangements or orders in place and something has occurred that the parent wants to withhold the children. So under the law, you can withhold the children, or you can what we call breach the orders, only if there is a reasonable excuse for doing so and that you do not withhold the children for any longer than is necessary. So, for instance, if you have to withhold the children because you've got to take them to a specialist appointment or a hospital appointment, and the other parent is not doing so, then you can withhold the children for that period of time. But once that appointment is over, you would have to return them back to the other parent. So it's really important. You can't just say, hey, the child doesn't want to go, so I'm going to withhold. If there is an allegation of abuse, sexual or physical abuse, then you could withhold the children until you have had it investigated to make sure that the children are no longer at risk of harm. And once you have that investigation completed and are satisfied that there's no longer a risk, that child needs to return to the other parent for time. If you don't, then you run the risk that there will be a contravention application against you, and you could actually end up with things like costs awarded against you, fines. Worst case scenario, you could end up either losing the children or imprisonment. So it's a very serious thing to breach an order, so you want to be very careful and be very strategic about how you're going to do it to make sure it doesn't backfire on you. So number 5 is, when is a child old enough to make their own decisions about who they want to live with? So this is a really interesting question, because technically under the law, the answer is 18, when they're an adult. There is no set piece of legislation which says there is a specific age in relation to children. But what they do is they actually look at a few things. So they will look at a child's age. They will also look at the maturity of the child. They will look at the decision that the child is making, and they'll look at the child's understanding of that decision and the repercussions of that decision. Now, in my experience, I have not seen a court make an order that goes against a child's wishes once they hit 15. I have seen them also make orders that follow a child's wishes from as early as the age of 7 or 8, because that was a very mature child and they had a very clear understanding of what they wanted. But on average, standard rule of thumb is at 14, unless those wishes are extreme. And for instance, I want to live with Dad because he lets me smoke drugs and I can sleep with my girlfriend, I don't have to go to school. And I don't want to live with Mum because she makes me go to school and I can't do drugs, so that's a bore. Then in those circumstances, a court would actually not follow that child's wishes. But in usual cases, and majority of the time, then it will be that child will be able to make a decision from the age of 14. So I hope that gives you a little bit of clarity. It's really important that they know. But those are the top 5 questions that everyone tends to ask on a regular basis. So I hope that's helped give you a little bit more certainty about some of the questions that are